Hello and welcome to this module on legal development through judicial process. The aim of this module is to understand how judicial process affects the development of law. This development is due to the doctrines of stare decisis, Sub-silentio, and per incuriam, which find expression in Articles 141, 142, and 143 of the Constitution of India. The structure of this module is as follows. We will first understand the doctrines of stare decisis, prospective overruling, per incuriam, and sub-silentio. After this, we will analyze Articles 141, 142, and 143 of the Constitution of India to understand how the judicial process leads to development of law. Now, we will begin with the concept of stare decisis. The doctrine of stare decisis was defined by the Supreme Court in Shankar Raju versus Union of India. The doctrine is expressed in the maxim stare decisis et non quieta movere, which means to stand by decisions and not to disturb what is settled. The rationale behind this doctrine is to allow for certainty and consistency in law. Further, in the absence of stare decisis, litigants would keep appealing every decision with the hope of a different outcome, even though the issue in question has already been decided by higher courts. A departure from this doctrine should only be made in extraordinary circumstances, allowing for organic development of the law. The doctrine of stare decisis works in accordance with the hierarchical structure of courts in India and works in conformity with the doctrine of binding precedent, whereby decisions of higher courts are binding on lower courts. I hope you have understood what the doctrine of stare decisis means. It essentially works with the doctrine of binding precedent to ensure that decisions of higher courts are binding on lower courts and thereby provide for certainty in the law. For instance, the decision of the Supreme Court is binding on the High Court, and the High Court cannot decide in a manner contrary to an existing Supreme Court decision. Having understood the doctrine of stare decisis coupled with binding precedent, we will now look at the doctrine of prospective overruling. Prospective overruling refers to cases where a decision specifically mentions that the ratio is applicable only to future situations. If such a specific mention is not made, decisions are supposed to be binding even on previous circumstances. Applicability of the doctrine of prospective overruling is left to the discretion of the court, and unless a specific mention is made regarding the prospective overruling of a particular judgment, it is always assumed that judgments do apply retrospectively. Having understood the concept of prospective overruling, we will now proceed to the doctrine of per incuriam. Decisions rendered per incuriam are not binding on lower courts. Per incuriam decisions are those made without due regard or in ignorance of an existing statute or binding authority. Thus, if a high court decides without considering an existing statute or a binding authority, such as a decision of the Supreme Court on the same point of law, that decision of the High Court will be called per incuriam and hence will not be binding on lower courts. Having understood the concept of per incuriam, we will now proceed to decisions sub-silentio. A decision sub-silentio is also not binding on lower courts. A decision is sub-silentio if the point of law was not perceived by the courts and a decision in that regard was not express and accompanied with reasons. When there is no conscious consideration of an issue by the court, such a decision cannot be contemplated to be included within the scope of Article 141. A court may consciously decide in favor of one party because of, say, point A, which it considers and pronounces upon. It may be shown, however, that logically the court should not have decided in favor of a particular party unless it also decided point B in favor of that party. But point B was not argued or considered by the court. In such a circumstance, although point B was logically involved in the facts and although the case had a specific outcome, the decision is not an authority on point B and point B is set to pass sub-silentio. It can now be understood that the doctrines of prospective overruling, per incuriam, and sub-silentio are essentially exceptions to the doctrine of stare decisis. This is because once these doctrines come into existence, the decision is no longer binding on lower courts. For instance, in prospective overruling, the ratio is only binding for future situations, and decisions rendered per incuriam and sub-silentio are not binding as well. Having understood what these doctrines are and how they affect the development of law and binding precedent, we will now proceed to analyze provisions of the Constitution of India that incorporate them. The first provision that we will consider is Article 141 of the Constitution of India. For the purposes of discussion of provisions of the Constitution, it would be helpful if you have a copy of the Constitution before you so that you can refer to the provisions of the articles simultaneously during the lecture. First, we will proceed with Article 141 of the Constitution. Under Article 141 of the Constitution, the law declared by the Supreme Court is the law of the land and is binding on all lower courts. The text of the article refers to declaration of law and not enactment. Thereby, decisions of the Supreme Court are not statutory enactments but do constitute a declaration of the law. The Supreme Court has the power to alter existing laws in this process by interpreting them and declaring a new aspect of a law. In cases of divided decisions, it is only the decision of the majority that is binding, irrespective of whether the judges who gave the majority opinion did so for different reasons. It is important to note that only the ratio decidendi is binding and not the obiter dicta. The ratio decidendi is that crucial point of law that has been decided by the court which can be relied upon in the future by other courts and lower courts who are faced with a similar question of law. The obiter dicta, on the other hand, is an observation or legal suggestion by the court, not arising in a manner so as to require a decision by the court. Obiter still does have persuasive value before the court, but it does not have a binding effect on lower courts. Thus, only the finding of a court on a specific issue raised and not the general observations of the court can be considered as law declared by the Supreme Court under Article 141 of the Constitution. In Ram Prasad Saruna versus Mani Kumar Subba, it was held that a decision is available as a precedent only if it decides a question of law. While determining if a decision has declared law, a judgment of the court has to be read in context of the questions which arose for consideration in the case where judgment is delivered. A decision which is not expressed and not founded on reasons, nor preceded on consideration of an issue, cannot be deemed to be law declared to have binding effect contemplated by Article 141. Any declaration or conclusion arrived at without application of mind or preceded without any reason cannot be deemed to be a declaration of law or authority of a general nature binding as a precedent. When the Supreme Court proceeds on the basis of a concession, the decision cannot be binding and cannot be held to be law declared under Article 141. Further, orders made with the consent of parties and with the reservation that the same should not be treated as precedent cannot have a binding effect under Article 141. This is useful to understand that while Article 141 does give wide-ranging powers to the Supreme Court to declare law that is binding on lower courts, while applying this provision, it is important to keep in mind the various situations where decisions of the Supreme Court will not be binding, say for the presence of obiter dicta or because of a lack of reasoning attached with the judgment or because the court proceeded on the basis of concessions or reservations. Because Article 141 gives binding value to all the decisions of the Supreme Court, a judgment of the High Court which refuses to follow the decision and directions of the Supreme Court will have to be set aside and can be considered to be a nullity. Decisions of a larger bench will prevail over previous decisions made by a smaller bench. Thus, decisions of 3-judge benches will prevail over decisions of 2-judge benches. Where the earlier decision is given by a bench of equal number of judges, in case of a contrary opinion, the latter bench cannot overrule the earlier decision. However, it can transfer the matter to a larger bench for a final decision to be made. In Shenoy and Company versus Commercial Tax Officer, the court considered the scope of Article 141 when the decision of the Supreme Court has not been appealed against. The court held that a law of the land would govern everybody, and the non-consideration of the principle of res judicata will not be a ground to reconsider the judgment of the Supreme Court. This goes on to show the binding value and the authority given to decisions of the Supreme Court under Article 141 of the Constitution of India. Now that you are acquainted with the scope of Article 141, it is interesting to look at an issue raised by Mr. Fali Nariman, who has proposed that decisions of 2-judge benches should not be considered as law for the purpose of Article 141. According to this proposal, the decisions of 2-judge benches should be binding on the parties to the case but not be considered as binding precedent. The constitution of 2-judge benches has been so questioned by Mr. Nariman due to the stark difference and contradictions in the decisions of multiple 2-judge benches. Thus, in his opinion, removing the precedential value of the 2-judge benches will reduce problems of inconsistency in Supreme Court decisions. Further, the court will not have to conduct a lengthy process of analyzing 2 contradictory judgments and then deciding which judgment to follow. Since the contradictory 2-judge benches will not have binding value, the court will be free to adopt any of these decisions. While this move seems useful in ensuring certainty and consistency in the law, it is important to consider what the drawbacks of such a move might be. One of the drawbacks of such a move is that it may result in more contradictory judgments, as two-judge bench decisions will no longer be binding. It could also result in a wastage of judicial time, as courts may have to keep deciding on matters that have been decided by previous two-judge benches due to the lack of binding value. Hence, there is an interesting debate that can be entered into to decide how the problem of conflicting decisions by multiple two-judge benches should be dealt with. If you are interested, you should read more on this topic and probably try to come up with arguments of your own to either go for or against the binding value of two-judge bench decisions. Having dealt with Article 141 in detail, we will now proceed with Article 142 of the Constitution of India. Article 142 of the Constitution empowers the Supreme Court to pass such decree or order as may be necessary for doing complete justice in any matter pending before it. This provision also empowers the Supreme Court to issue directions where none already exist, and such directions shall be binding till such time as new rules are enacted by the legislature on the subject. The object of Article 142, subclause 1, is that the Supreme Court must not be obliged to depend on the executive for enforcement of its decrees and orders. Such dependence would violate the principles of independence of the judiciary and separation of powers, both of which were held to be part of the basic structure of the Constitution. The scope of Article 142 and its interaction with statutory law has been a point of contention. There are multiple approaches taken to understand the scope of powers of the Supreme Court under Article 142. The three approaches that we will be discussing in this module are the broad interpretation of Article 142, the narrow interpretation of Article 142, and the harmonizing approach. We will first deal with the broad interpretation of Article 142. A broad interpretation implies that Article 142 is a source of substantive power for the Supreme Court to fill gaps where there is a vacuum in law. In Delhi Judicial Services Association versus State of Gujarat, it was observed that the power of the Supreme Court under Article 142 to do complete justice was part of the basic structure of the Constitution and thereby entirely of a different level and quality. Any prohibition or restriction contained in ordinary laws could therefore not act as a limitation on the constitutional power of the Supreme Court. In Union Carbide versus Union of India, the Supreme Court stated that prohibitions or limitations on or provisions contained in ordinary law could not ipso facto act as prohibitions or limitations on the constitutional powers under Article 142. In exercising its powers under Article 142, the Supreme Court can take note of express provisions in any substantive statutory law based on some fundamental principles of public policy and regulate the exercise of its powers and discretion accordingly. Thus, the Supreme Court clarified that it does not exercise its powers under Article 142 in direct confrontation with statutory law. I hope you've understood the argument made by those proposing for a broad interpretation of Article 142. What this essentially entails is that the power of the Supreme Court under Article 142 is very broad and is part of the basic structure of the Constitution, and hence this power cannot be restricted by any other provisions, including statutory law. However, the Supreme Court has clarified that it usually would not directly act in complete contravention with statutory law and would apply its discretion whenever a situation of conflict with statutory law arose. This concludes the discussion on the broad approach. We will now deal with the narrow approach to Article 142. A restrictive approach of Article 142 stems from the argument that it only provides procedural powers and not substantive powers. This interpretation rests on reading and understanding Article 142, subclause 2, which states that the Supreme Court is empowered to do the following under Article 142, subclause 2. First, secure the attendance of persons before it, call for discovery and production of documents, and investigate and punish for contempt itself. Thus, as you can see, the actions mentioned in Article 142, subclause 2 are essentially procedural and hence tend to point towards the restrictive argument. While the third power, relating to investigation and punishment for contempt, appears to have substantive elements, proponents of the narrow interpretation argue that Article 142 is actually supplementing Article 129 of the Constitution, which provides the substantive basis for punishment of contempt. Further, they argue that the wording of Article 142 is similar to the wording of the inherent powers of the court provided in Section 151 of the Civil Procedure Code and Section 482 of the Criminal Procedure Code. Since the powers in the civil and criminal codes are procedural powers, it is argued that the power under Article 142 is also procedural. Now let us look at some case law that argues in favor of a narrow interpretation. In Prem Chand Garg versus Excise Commissioner UP and Allahabad, the Supreme Court, while interpreting Article 142, stated that the purpose of this article was to allow the court to take procedural actions like admitting additional evidence, adding parties to proceedings, and allow the court to depart from procedural requirements in order to do complete justice. This indicates that the power under Article 142 is restricted to procedural matters. Now, as you can see, the broad interpretation of Article 142 and the narrow interpretation of Article 142 essentially conflict on whether the powers under Article 142 are substantive or procedural, and whether the Supreme Court has the power to ignore or conflict with existing statutory law. In order to deal with these competing approaches, the Supreme Court has adopted a harmonizing approach, and this is the approach that we will be looking into now. In Bonkia vs. State of Maharashtra, it was held that the amplitude of powers available to the Supreme Court under Article 142, subclause 1 of the Constitution is not normally conditioned by any statutory provision. However, it cannot be lost sight that the court exercises jurisdiction under Article 142 of the Constitution with a view to do justice between the parties, but not in disregard of relevant statutory provisions. Thus, as you can see, the court has started off with a broad interpretation by saying that under Article 142, it is not normally conditioned by statutory provision, but tends to adopt a bit of the narrow interpretation as well by saying that the court would not normally act in disregard of relevant statutory provisions. Similarly, in Supreme Court Bar Association versus Union of India, the Supreme Court cautioned against the unbridled power under Article 142. The court stated that while the power under Article 142 was not controlled by statutory provisions, the power was not meant to be exercised in direct conflict with a statute dealing expressly with a particular subject. This was clarified further in Lakshmidas Morarji versus Bhairob Darab Madan that the power under Article 142 is to be used sparingly in cases which cannot be effectively and appropriately tackled by existing provisions of law, or where existing provisions of law cannot bring about complete justice between the parties. Thus, the harmonizing approach takes on bits of the broad approach, that is, by saying that the power is not usually conditioned or restricted by statutory law, and then takes on bits of the narrow approach by stating that the court will not normally conflict with statutory law. And finally, the court has sought to bridge the gap between these two approaches by adopting a harmonizing approach by saying that the power under Article 142 will only be used in exceptional situations where the existing provisions of law itself are insufficient to do complete justice between the parties. It can still be argued that the power and the scope of the scope under Article 142 is largely undefined, and in several cases, while the Supreme Court has stated that it's not restricted by statutory provisions under Article 142, it is also stated that the very nature of the power under Article 142 is such that the court must impose restrictions on itself and not use it in situations where it contradicts with statutory law. Therefore, an interesting point of research is to look at all the case law that the Supreme Court has on this particular article and then try to define the scope and the width of this particular power. This concludes the discussion on Article 143 of the Constitution. We will now proceed to analyze Article 143 of the Constitution. Under Article 143(1) of the Constitution, the President can refer a question of general public importance to the Supreme Court. Under Article 143, Subclause 1, the Supreme Court is not bound to decide on the question referred. Neither is the President bound by the opinion of the Supreme Court. In the Kerala Education Bill case, the Supreme Court observed that the opinion of a reference under Article 143 may be declined in a proper case and for good reasons. Some of the reasons for refusal to decide on a special reference are if the court decides that it is improper, inadvisable and undesirable, or if the questions formulated have purely socio-economic or political reasons with no relation whatsoever to the provisions of the Constitution, or if the questions are incapable of being answered, or if answering them would not serve any purpose, or if there is authoritative pronouncement of the Supreme Court which has already decided the question referred. The discretion of the Supreme Court does not extend to determining the extent of malafide behind the reference. However, in all but one of the special references made to the Supreme Court, the court has delivered an opinion. The only case where the Supreme Court refused a reference was Union of India versus Dr. M. Ismail Farooqi and others, where the court stated that the relevance did not serve any constitutional purpose. No specific format has been provided for framing of the reference. In the Keshav Singh case, the Supreme Court observed that no specific pattern had been followed in all the presidential references before the court, and that this was consistent with the broad scope of Article 143. A decision of the court made by way of special reference can only be reviewed under Article 137 of the Constitution or a curative petition. In the 2G spectrum reference, the court identified three general principles to determine the scope of Article 143. First, a reference should not be vague, general, and undefined. Second, the court can go through the written briefs and arguments to narrow down the legal controversies. And third, when the question becomes unspecific and incomprehensible, the risk of returning the reference unanswered arises. According to In Re the Special Courts Bill 1978, a reference has to be for a specific question. However, it is not necessary that this question has already arisen. The President can send a reference even at an anterior stage if convinced that the question may likely arise. It is for the satisfaction of the President to determine if a question under Article 143 has arisen. However, the President can refer a question of law only when the Supreme Court has not decided it. While dealing with a special reference, the court does not sit as a court of appeal from its previous decisions. In case the court decides to deviate from any of its previous decisions, it does so in exercise of its inherent powers and only in exceptional circumstances. In the 2G spectrum case, a controversy arose regarding the difference between a presidential reference under Article 143 and an application for review of a judgment of the Supreme Court. The court stated that a review is completely different from a reference under Article 143. A review is list-specific, that is, dispute-specific, and relates to the rights of the parties, whereas a reference is answered keeping in view the terms of the reference and requirements under Article 143 of the Constitution. Thereby, merely because a review has been filed and withdrawn, the same would not be ground for refusal of a reference. In this regard, the court states that while exercising jurisdiction under Article 143(1) of the Constitution, the Supreme Court can look into an earlier decision for the purpose of whether the contentions urged in the previous decision raised a general issue or not, whether it was necessary to consider the larger issue that did not arise, and whether a general proposition had been laid down. This concludes the discussion on the scope of Article 143 of the Constitution, as well as the module on the legal development through judicial process. Make sure you solve the self-check exercises provided at the end of the module. This will help test your understanding and direct you towards further research in this area. Thank you very much for listening.